I restricted his phone call. I basically took away his phone privileges in the jail. And the way that we did that was through AgSeg, administrative segregation, where he is now housed in a separate part of the jail that does not allow any access to phones. Did I miss anything?
That's a good summary of what happened.
Still has nothing to add.
So we're here today because counsel for the defense has issues with the order that I did.
Hey there, welcome to the Courtroom Files. So this video from Judge Fleischer's court shows us that things aren't always as easy as we would want them to be. One of the things we often see in the comments on our various videos, and by the way, we don't blame anybody for this, but there's this desire to just go to the extreme or to the final answer, like, why doesn't the judge just put him in jail? Or why don't you just do this? Or why don't you just do that? And we totally get it. We kind of look at things that way too from time to time. But the more and more we watch these videos and the more live feeds we scan, and it's hours and hours every day, you realize that it's just not that simple to get things done. So in this particular instance, we have a person who is in jail and he's had his phone privileges taken away by Judge Fleischer because he was doing bad things with the phones, but there is now an issue of the way he is being segregated in the jail, of his lawyer having access to him where their conversations are privileged. And, you know, that's a constitutional right that this defendant has, regardless of what he's been accused of. He has to be able to have access to his lawyer that is in private, but it's difficult to get it done. And you'll see that in the video, kind of the circumstances that they're facing. So we present this as a lesson in that, and also the arguments and what's going on here are interesting too, but it's very much a lesson in how things just aren't always simple to get done the way we might want them to. But in this case, they have to find a way because he has a constitutional right to his lawyer. So take a look at it. Let us know what you think in the comments about how the judge is handling it and about the concerns that the defense has. Put a like on the video if you enjoy it, and yeah, enjoy the video.
All right, so we're on the record in cause number 253-4377. Also 2505-146. And today's date is 10/21/24, October 21, 2024. It's approximately 11:50 in the morning. Guys, I'd like you to announce yourselves for purposes of the record, please.
Michael Haddad for the state.
Anna Edie on behalf of Mr. Wiggins.
Okay. We were here late last week, and the reason that we were here was we had a prosecutor here for the work with the Domestic Violence Division approach me with Miss Edie and tell us that Mr. Wiggins has been making threatening phone calls from the jail to the complaining witness in this case. Not only was he making threatening phone calls, but he was also using two other SPIN numbers from other inmates to also try to make phone calls to the complaining witness, you know, and make threatening statements saying that, number one, he was going to do harm to her, that he was going to not follow bond conditions. And what I found was that not only is he a threat to society while he's out in society, because what we had in April of this year, he picks up an assault of a family member. A couple months down the road, he picks up 4 counts of aggravated assault and 5 counts of aggravated assault, 2 VPOs because he's allegedly shooting a gun in a car where there are at least 3 complaining witnesses. So I'd revoked the bond, I set it high, and it came to our attention that he's continuing while in custody still to be a threat to public safety. So what I did was, over objection from defense, I restricted his phone call. I basically took away his phone privileges in the jail. And the way that we did that was through AgSeg, administrative segregation, where he is now housed in a separate part of the jail that does not allow any access to phones. Did I miss anything?
That's a good summary of what happened.
State has nothing to add, Judge.
So we're here today because counsel for the defense has issues with the order that I did. I'll let you.
Okay. And before we get started, I just want to say that the Harris County Public Defender's Office represents Mr. Wiggins on his felonies. The designated representative, Christina Wong, is out of the office. And I've been unable to coordinate with the Public Defender's Office to get someone here. But they do have an interest in this. I would imagine that they're in alignment with my position. I can't speak for them, but the ongoing constitutional violation I thought was serious enough to approach without them.
Okay.
Okay. So Mr. Wiggins is not allowed to use any phones at all, which means he cannot call me or his felony attorney. The court had suggested that if he needed to get in touch with us, he could write a letter, put it in the mail, and then we could contact him. My issue with that is that all outgoing mail from the jail is opened and read, including legal mail. That's also going to add to a delay. So if Mr. Wiggins needs to speak with one of us urgently, we're going to have to wait for the jail to process it, put the letter back in the envelope, and then wait for the Postal Service to deliver it. So by that time, the problem could be worse. It could be overcome by events. Just the time delay on that. The other concern, and I'm going to show this picture to Mr. Hadid, when I went to visit Mr. Wiggins at the jail, because he's in administrative separation, this is the attorney room that we needed to use, and there's big red signs that says those phone calls are recorded. So I'm asking the court to allow Mr. Wiggins to contact his felony attorney and myself, and if we go visit the jail, that we do it in a way that those phone calls are not recorded.
I have absolutely no problem with you being able to go visit him in jail.
Okay.
And I would hope that they would allow you to have access to him as they would in any other instance when a person has the ability to go talk to an inmate. I have serious reservations about giving him access to phone privileges, though, as far as being able to call someone, because I don't know the protocol and I don't know if they have enough manpower to be able to sit there and actually look at who he's dialing. He's a threat to public safety, and he's a continued threat while in the jail. Not only is he's also using other inmates to be able to facilitate criminality. I mean, this is really the least restrictive means that we have to be able to protect the public. I don't know how else to go about it, because I certainly want you to be able to speak with him. And what we could theoretically do is have him come and put him on the docket every 3 days so that you can have continuing access to Mr. Wiggins. I'm happy to do that.
Well, the problem is that the holdover, there's no privacy. There's other attorneys.
We can wait until you guys are the last ones here, where you have the entire holdover to yourself. That's always a manner as well. We can put him in a separate room by himself there. But, you know, like I said, we can always wait till you guys are the last ones here, so you have complete and utter privacy and no one else there to influence him, or no one to hear what the conversations happen. But how can I, you want phone privileges, or what do you want?
I want him to be able to, I mean, I understand the seriousness of the allegation. I understand, you know, the court's concern, but my concern and my duty is to ensure that Mr. Wiggins has his Sixth Amendment right to counsel, and that his felony attorney and I can both provide effective assistance.
And I want that to happen. I don't want to restrict any kind of access. All I want is him not to be able to use the phone to call out to the general public. I don't know how that can happen if I give him just privileges to call you. Because the danger to be able to misuse that is just too great, and it's not so. Did you go see him?
I did, and
What happened?
so when I realized they were going to put us in that attorney room, they told me that that's the room we had to use. And I was unable to effectively communicate with Mr. Wiggins because those phones were not working. Now that's a completely separate issue. But I reached out to.
Even if those phones had been working,
well,
they were recording.
They were recorded, and I don't know if the court is aware of how the phone system works at the jail, but normally you go into a private attorney room.
You have the phones, you pick it up, and there's the big plexiglass, and yes, those aren't recorded.
No, those are not.
Right.
But the room we had to use because he's in the administrative separation, which is the only way the jail can ensure he doesn't use the phone. It's a private room, but when you pick up the phone, it has a keypad for Mr. Wiggins to put in his SPIN and PIN number to record that call. And like I said, you can see the huge signs that say,
Right. So do you want to bring him here every couple of days so we can have just continuing meetings and we wait till the last people are out and you can have contact with him?
well,
I don't know how else to do it at the jail.
I don't either, but I have concerns about, the cost involved in transporting him every 3 days.
You can't, what?
Don't
even worry about that.
Okay. I don't think that's sufficient to, for his felony attorney and I to provide effective assistance of counsel.
Judge, the way the motion is written, the state is unopposed, but we understand your concern about how the jail, with their internal procedure and where he's housed, is going to actually enforce that to where when he's on the phone, he's only calling and speaking to his attorney. So we're unopposed to the motion with the way it's written, but we also will refer to you and understand it.
I don't know how to do that, Anna.
Is there a way that, and I don't know the jail policies and procedures, but he could stay in the administrative separation, but the jail only allows him to call certain numbers?
No, that's what I'm saying. The risk of him trying to misuse that is just too high. And I mean, that would require the jailer to sit there and look at the actual number he's dialing, making sure that it's the right number. How are they going to know that?
Can I ask you, what was the policy for mail, for letters? Did you say he could send out letters?
Well,
okay.
I mean, he can send letters to the lawyer, but he's not supposed to.
But those letters are read.
Well, I know you said you're concerned about that. I know for a fact that they're not. They're only read in certain circumstances where if they feel. I don't want to discuss Harris County jail policies on the record without someone here to testify to that. But I will say that I have personal knowledge that not all mail is open and read. There's very certain circumstances in which it's opened and read.
I don't
for the
know.
general public.
I don't know how to do I don't know how to work it. Do you have any? I don't feel comfortable giving him access to a phone to dial out. That's for sure. He's proven that he's just too big of a danger to be able to give him access to a phone.
And if I could, Judge, I just want to point out that, not minimizing the allegations of the threats that were made from the jail, but he was not trying to coordinate with someone on the outside. I don't think there's been any allegations that he was trying to coordinate somebody to affect harm. He was just reaching out to the complaining witness.
He's not supposed to.
I understand he's not supposed to have any contact.
He's not supposed to. He's using other people's spins, continuing to make threats, and then blatantly saying that the bond conditions I'm not going to follow the bond conditions. I'm going to get out. I'm going to get me a damn good lawyer, and the bond conditions are going to go, you know where.
Well, and I would also point out that if he's in jail, he's not on bond.
He's still instilling fear
I
into a complaining witness that he shot at.
I understand. Just my concern is Mr. Wiggins and his ability.
Why don't we bring him here every other day? And I'm happy to do that as well. That way we have him wait till the end and you can meet with him. I'm not giving him access to a phone. Not with, I mean, it's been 2 days, 3 days,
Okay,
you know? I want to give you as much access as I possibly can over there, over here, however, but I'm not giving him access to a phone. It's inviting danger.
okay.
You know, and if someone else says that I'm wrong, hey, but he's not always a danger when he's out, but he's a danger when he's in.
Understood, Judge.
Perhaps now we'll get his attention.
Okay, can I enter the photo that I took as an exhibit?
Yes, absolutely.
And do I need to lay the foundation, or
Um,
I'm not sure how it works in this setting?
I guess, Ramona, you want me to have her file it and then we'll make it part of your record, I guess?
Judge, just let her offer it like she normally would, and I'll get it from her as soon as this is over.
Okay, at this time, I'd like to tender into evidence a picture of the jail showing that the jail phone calls are recorded. I'm offering it to opposing, or to the state.
The objection
The
statement.
state's unopposed.
It'll be entered as defense exhibit
One.
1 as for purposes of the record. I have not read your motion. Let me just
Okay.
see real quick what it says. So the motion is defendant's motion to allow confidential and telephone communication with his lawyers. I mean, I'm sorry. You know, it pains me to do it, Anna. It really does.
No, we just,
I can't. I'm happy to deny.
okay,
I don't know how else to micromanage to make sure that he's not using a phone in a malicious way. I don't know if the jail has the manpower to sit there and look at what the actual phone number that he's supposed to dial, watch him sit there and do it every single time.
well, they have the manpower to monitor his calls, which is how,
The problem is that there's no phones there. That's why we have him there. So they'd have to take him to another place, sit there, and then they're gonna watch him the whole time. you
I would
know?
have objections to that because,
And then if they go out of the room, he hangs up the phone, boom, dials another number real quick. You know, it's just too much.
okay,
So, sorry,
understood, Judge. May I be excused? Okay, thank you.
off the record.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.